Adrienne Moran from Shapiro, Galvin, Shapiro and Moran has joined us in the studio. It's great to have you here.
Thank you for inviting me.
We are going to talk about, this time on your visit, employment law. And I have a question for you, Adrienne. For somebody who might be watching this right now, let's say they're a manager, they're considering terminating an employee. What are the important things that they need to know?
You know, that's a question that comes up very frequently, and it's a very troublesome area, and it can lead to a lot of potential legal liability. So I always enjoy helping employers work through this problem and in a preventative way so that we can avoid problems. One of the key questions that employers ask me is, should I really tell them the true reason why I am terminating the employee, or can I just tell them that I'm laying them off for economic reasons? And my advice is always to tell the true reason. Give the truth to the employee. First, as a courtesy to the employees always really want to know what is the true reason, and often if they know from your heart what is the true reason, that will avoid disputes from arising. But also, if the employee falls into some protected status, age, gender, etc., then the employee, even though they are at will, the employee may claim later on that, well, you got rid of me because I'm over 40 or I'm female or whatever I might be. And so then the employer's obligation is to prove that no, the reason I got terminated your employment is because of a legitimate business reason. And so if the employer wasn't truthful up front about what the reason was, it makes the employer look like they are not being consistent with the reason and not being credible. So tell the true reason for the termination. And then always give the employee something in writing about the change in the employment relationship. You're required to give them something in writing advising them that they are either being laid off for economic reasons, demoted, terminated, whatever the case might be. And then make sure that you provide the final compensation on a timely basis. And that's an area where the employer often falls in violation of the law because they wait, for example, until the next payday to pay the final pay. And the law requires them to pay the final compensation if it's a termination on the date of termination. And if the employee has quit but given at least 72 hours notice, they must pay that on the day of termination.
Documenting the employee's record all the way through employment is important, am I right?
It's very important because if the employee sues the employer later on for some discrimination claim, and the employer claims that, no, I got rid of you because of performance issues, but the personnel file is completely vanilla, that's going to be a problem. So you always want to make sure that if there are performance issues, that you have documented them, but also the documentation gives the employee the opportunity to have fair notice of what your expectations are and gives them the opportunity to attempt to improve their performance.
When a termination occurs, should a witness be in the room?
It's always a good idea to have an HR person with you or another person there. And the HR person is helpful because they can answer questions that pertain to benefits, COBRA, for example, and other things that the supervisor might not know about.
If somebody needs to reach out to you for more professional advice, how do they contact you?
They're welcome to contact us through our website or telephone our offices, or by email is great. We're very prompt about getting back to folks, and we really look forward to helping people prevent problems from happening. And so it's worth that short telephone call before you make a termination decision to make sure that you're doing it correctly.
Thanks for coming into the studio.
Thank you.